that click record
There he
button.
goes. That's right.
Okay, and then the other thing that I wanted to mention to you is we've got a large amount of materials to cover. Each one has a lot of depth in and of itself. As we go through this seminar, please keep in mind we are kind of pushing the envelope in terms of presentation. And so if something doesn't make sense to you, please slow us down and have us ask your questions along the way. With that said, let's talk about market forces and what's in play. A lot of times what we hear about is, why does my healthcare contract take so long to get through the processing part of it? And there's several reasons for that. One is probably because you're in the healthcare industry, you're dealing with a not-for-profit or a healthcare governmental provider, and they have their own forces that are driving them. One is the community benefit that they provide to the hospital, to the local community. How much are they improving health by? What are the key areas of improvement that they need to focus on? And then the other thing that they're also getting evaluated on is, how efficiently did they do it? What percentage of the population did they actually impact? So with that, there's a lot of rules that play into it, and that requires a lot of compliance issues. And with government and not-for-profit hospitals, government has its own statutory requirements. And if you've got a government or a state or a county hospital, it's going to have its own statutory requirements it's got to go by. And if you've got a not-for-profit hospital, you've got the 501c, whatever that version is of the hospital, that's got to then conform to the not-for-profit rules. So it ends up being a really a spaghetti bowl of a lot of regulations coming into play. And that really is a short of the answer, and we'll walk you through the long of the answers coming up in our presentation. Anything else, Ed, you'd want to add to that?
No, I mean, as you'll see as we go through this, depending upon the type of contract, there's a complexity that has to be addressed on each one, and that does take time before make sure we have the law in place and understand the regulations that regulate this particular type of arrangement and have the right facts. And that's often plays into the time it takes to deal with the contract.
Okay, so today's presentation is going to be roughly about, we might be able to cut it down to 45 minutes if we're pushing it, but it's going to be roughly about 50 minutes long. There's going to be about a 10-minute leeway for Q&A if you guys have any questions. However, again, if we do tend to kind of go fast through something, do ask your question. We're going to first touch on healthcare systems and operations and how those are different, right? So like how they're different than most other organizations. We're going to go through the uniqueness of contracts in healthcare, and what are some of these quirky clauses that are going to get your contract stuck. And we're going to be talking about contracting and complying with bond financing. A lot of our not-for-profit hospitals have bond financing that they're involved in, so they've got their own set of rules and regs that they've got to comply with. And last but not least, there are Stark law changes coming up in 2021, which is also something we're going to touch upon, but really we're going to discuss it in detail further in January. So do tune in for that if you want to tune into like what are the Stark law changes, and they are fairly significant. So that's coming up. And all right, so let's start off with healthcare operations and the vendor agreements that healthcare operations involves. Think of a healthcare operation as literally like, especially when you're looking at hospitals, like a little city or a resort. It's got food services, it's got janitorial supplies, it's got laundry stuff, right? Then you've got to make sure that there's a supply chain that's providing not only this day-to-day living stuff, but the actual medical component of it, anywhere from bandages to sutures to diapers to medicines, the pharmaceutical stuff. So there's a whole supply chain behind it that's playing into it. Now you combine that with the whole system is driven by information technology. Information technology and the computer sort of involvement that's there is really pretty hefty, because now you've got to come, that's compounded with like all of the HIPAA regulations that go into. So like health record storage becomes hugely important, how it's transmitted, how it's maintained, and so forth. Then you have certain really unique contracts like art rental agreements inside a hospital. If you go into a hospital from time to time, you'll see that the artwork inside a hospital is changed out periodically. And you're like, how is that happening? They've got these great expensive pieces, but it's actually rented material, right? Then we'll also, then the other things you'll see is transport. There's air transport and there's ambulance transport. Air transport for the incoming patients, and then there's air transport to go out and retrieve like organs and things like that. So it's got transfusions, transplants involved in this. So along the way, you've got to have all of this stuff lined up in contracts, and now you've got a lot of things tugging on the same one economic animal, which is your healthcare system, and it's getting pulled by different vendors at the same time, and it's got to engage those vendors in a relatively efficient manner. And
Yeah,
with that, go ahead.
No, what I
I'm sorry.
mentioned, that to give an example of the complexity that even one of these might deal with. Let's say you're dealing with air transport. You might have an airplane transport arrangement dealing with a level 4 trauma center where you have a helicopter coming in. But to line that up, you have to obviously have the contract with the helicopter company. That contract has to meet certain laws and regulations dealing with those type of transports. FAA rules may come into effect. The contract with the physicians that get on that transport, the nursing staff that might get on the transport and go into issues regarding stocking of of that air transport for resupply. All those, there's many different aspects that will come to play in any one of these agreements that have to be taken into account. That creates the need to review it thoroughly and to make sure that the arrangement itself is complying, especially when reimbursement is involved, the government reimbursement is involved.
So before we go on, I just want to make it a point that I've actually entered into some really interesting contracts. One was actually a skin grafting contract. Where do you get skin from to be able to graft it onto people, which is relatively unique, and you can see that in like burn victims and so forth, right? So that's kind of cool. The other thing that I also had to engage in, and I couldn't believe it, was transplant of some of the internal works of your intestine from one patient to another because they don't have the bacteria in their system. So what they were doing was contracting for supply for, intestinal specimen so they can transfer it from one person to a patient. Those are some of the uniqueness.
There's definitely some odd contracts that pop up in the healthcare field. Yes.
So, and then depending on if you're transmitting, patient information, you may have a business associate agreement to enter into. The other uniqueness of healthcare systems is that there is often governing medical staff bylaws, medical staff rules and regs, and then there's also the steering committees on the inside, and a lot of the work that happens inside a hospital has to get reviewed and approved by the medical staff. The medical staff is obviously the actual driver of the business, so they're the ones that get to make that decision, not just business people alone. So they've got to be given a due level of respect and deference, and so the medical staff you'll see pop up time and time again, and you'll see it in different variations in your contracts. So with that said, now this slide is literally about where the hiccups occur. Okay, so oftentimes these are roughly about 10 different provision types, and these provision types are usually fairly one-sided. If you're on the healthcare provider side, if you belong to a hospital, it's going to be fairly one-sided, and it's going to be where the vendors are going to feel like they're getting shorted, but there's good reasons for that. Starting off with indemnification, release and waiver, right? There's always a struggle for who's going to take more of the liability should something go wrong. Should a product warranty go bad? Should a procedure or a service go wrong? Who's going to be responsible for indemnifying which side? So there's always clauses that are proposed. One is it'll try to insulate one party against the other because they presumably had no part in it, or they'll try to partner with each other and share a part of that blame in case if something does go wrong. And this is why it's really important to take a look at indemnification, release, and waiver clauses really closely, because people think that they're all alike, but they're really not. They're actually very different, and they come in all variations. You can have you can have indemnification, release, and waiver clauses where they insulate one party and make the other party a scapegoat. You can have them be half and half in the middle, and it's a nice sharing of that responsibility, but it depends on the business.
And one piece always, where they can be different, and is this issue of intentional acts, indemnifying for intentional acts, which I see in contracts once in a while, and keeping in mind that you cannot insure against something one intentionally does. So you have to be very careful about intentional acts. So an intentional act could be a theft, intentional theft by one of your employees, or an assault made by one of your employees that comes into that hospital under the contract, and that's an intentional act, and all the damages that might be done are not insurable. Though if you've agreed to an indemnification for intentional acts, you're still responsible for the damages that are caused by that.
That's a really good point, Ed. And and I'll add to that as well, is that there's multiple different types of insurance provisions. There's obviously general liability, property damage, professional liability. There's auto coverage, machinery coverage. I mean, it just goes on and on. If I look it up, there's literally like 25 different types of insurances. But what you want to do is you want to make sure that the insurance provisions that are included in your contract are pertinent to you. They're pertinent to the business at hand. A lot of times what you'll see is an overstuffed contract where they've got so many insurance provisions in it that it actually kills a deal. You got to come in and you got to peel off the layers that you don't need and would be deemed unnecessary.
I was dealing with a contract that's very similar to that a little while back, where the hospital, actually their executive was a former insurance broker. So he wanted to put every type of insurance in there and state all the different limits, keeping in mind that in litigation, the plaintiffs might get a hold of that contract. And if they look at the insurance provisions, they now have a roadmap of where money is available under insurance policies for different types of causes of action they might seek. So you got to, keep that in mind. Well, insurance is really important for the contracting thing, but in plaintiff's world, you may not need to have be so specific on levels, as long as you actually do have the levels you need.
And Ed, you're absolutely right. I actually litigated for about 15 years, and in my litigation, there was always a component of insurance, right? So if I was on the plaintiff side, I'd be looking for insurance with pockets that I can actually tap into. And then vice versa, if I was on the defense side representing somebody, I would be looking for insurances that I can push off the actual responsibility to help pick up that coverage. Right. So if you list them in the contract, all you're doing is throwing out more stuff for people to come and attack you on. So just be careful on that. The other thing that you may want to keep in mind is there's also a provision, what's called access to books and records. Access to books and records means that literally one party has the ability to come in and ask you for your books and records of your organization. And it seems very onerous. But the reason why it's there is because CMS, Medicare, the federal government says anytime you're going to do a contract that's $10,000 or higher, or you've got a contract that goes on for longer than a 12-month period, access to books and records is going to be a part of your requirement. So that not only applies to the actual healthcare system itself, but it'll apply to the downstream vendor as well. And that's how the government wants it applied, because if you're going to turn around as the healthcare system and bill back Medicare on a cost-based reimbursement, Medicare is going to say, I want to see the books and records of your downstream vendor. So it becomes really critical to seeing that. There's also like the non-discrimination provisions. Obviously there's a federal, state, and local levels, but that's it not only applies to employees, but it also applies to patients that are coming into the ER, and patients that are getting administered healthcare provisions, right? So when you're giving them provisions, you cannot discriminate based on the same constitutionally protected issues, plus whatever has been instituted locally. Like, for example, San Francisco has one on sexual preference, right? So they also say you cannot discriminate on not just gender, race, religion, but also they added on sexual preference
Identity, yeah,
as,
identity, yeah.
as a protected class.
Yeah.
So those are your non-discrimination provision. The other thing, and I think Ed's going to have some stuff to say about this, which is, you've got to get compliance on excluded persons. If you don't know what an excluded person is, you got to tune in next month, go through our Stark and anti-kickback seminar.
Right.
But the excluded person's got to be kept out of this game and out of this mix. Healthcare systems are very, very wary if there is an excluded person that's showing up on the Medicare list that's in your staff, that's a physician, or that's involved in billing. Those three are like automatic triggers, and that's like a no-starter. You got to get those people out of there. You can't even have them show up, even if today they may be as honest as the day is long, but somewhere along the way something didn't quite go right, and you got to pay attention to that. Ed, you want to add anything?
Yeah, no, because again, the government does not want to be paying for arrangements that include services being delivered in part or organized in part by someone who the government has said you're excluded from the program. So, which is important because to make sure that the other party is doing a review of all the people they're dealing with to make sure there's no one excluded. And it also goes into the next section, which is representations and warranties. Because in reps and warranties, what you're doing is you're shifting the risk. One common rep and warranty is a warranty that no one in each side is excluded from Medicare. And that's an important warranty because if for some reason service is being provided by someone who's excluded by Medicare, and the hospital bills for that service of someone excluded for Medicare, and Medicare turns around and dings the hospital for it, that hospital now has a warranty by the physician group that have warranted that no one's been excluded. So they can now go on that warranty to recover and reconcile themselves to the claim they made. Similarly, warranties on licensing. Everyone has a proper license, so a hospital cannot bill for services that of someone who's been not certified or not licensed. So if someone loses their license, the hospital can't be billing for that. So there's a warranty in that arrangement that everyone doing the service will always be licensed.
Now, the other part of reps and warranties is also making sure that your quality assurance programs are in place, that your proper billing compliance is in place, that you're making sure that the HIPAA requirements are also satisfied. That's also part of what's often included in the representations and warranties. And there's also a provision called changes in law. That also means, and that's kind of like a double-edged sword on that one. In a lot of contracts, you'll see if there is a change in law, the parties reserve the right to go back and modify the contract to comport with that law. Because if in case they were doing something that may in fact rub the new version of the law the wrong way, they may go back and try to renegotiate that. And they will renegotiate it. And once they do, you come up with like a whole new set of or whatever those modifications were, and you'll negotiate them. And if one party is not able to live with it, then you know what? Then they have the right to actually terminate that contract. So changes in law is actually a provision. It is enforceable. It is out there. Business associate agreements. Going back to, you're going to need a business associate agreement in these sorts of instances when you're either consulting with somebody or somebody's consulting with you or billing or providing services and that involve patient information, right? So PHI. If there's patient information that's being created, transmitted, or stored, including like cloud services, you're going to need a BAA. So you got to get a BAA put into relationships where you've got what's considered a non-covered entity. A covered entity you don't need a BAA with. Ed, you want to explain maybe what a covered entity is?
Yeah, covered entity. Like the healthcare providers themselves, those are delivering healthcare. So, for example, what I'll often see is a request that the physicians who is being the medical director and doing administrative services needs to have a BAA in place, because they're saying, well, yeah, you are a physician, which is a covered entity, but you're providing administrative services. But if you actually go back and look through these regulations, you realize that what they're doing is all part of an organized healthcare arrangement. These healthcare providers are organizing themselves for the delivery of care, and they're already covered by the obligations under HIPAA. So a business associate agreement is not necessary.
Medical staff bylaws is another requirement you'll see in some contracts. If you have a product that requires medical staff approval, you're often going to find that as a provision embedded in that contract, that that the medical staff has a right to review and exercise and diligence and quality assurance to make sure that your product or service comports with that. Medical staff is a critical part of those contracts. It often has in it like due process rules that also play into it. So you'll often see that, and so don't get wigged out by it. Right. The other thing that you may want to look at is if you've got a larger size institution, especially governmental hospitals, they'll have what's called a RFP, a request for proposal. Oftentimes they'll start off with a request for information where they find out what all the vendors are doing and what they're able to offer. Then they'll put together a request for proposal, which goes out. Then everybody bids on it. The RFP process is very unique in and of itself. There's a way to bid for things. There's a way to comport with their requirements. Then there's ways to actually dispute the RFP and the outcomes of the RFP to make sure that you were looked at fairly. So, or what you did was appropriate and fair. So these are, again, these terms are going to often be your snagging points, and everything else you're going to negotiate on is going to be business terms. But these are highly legal, technical, healthcare things to look at. Are we going too fast? Anybody have any questions so far? Okay, good. All right, so when it comes to government contracts, and we just wanted to actually touch on this real quick. One is, when it comes to government contracts, remember, government agencies have sovereign immunity. Sovereign immunity means that you generally cannot sue them for what's considered a tort. So like negligence would be a tort, or a wrongful doing would be a tort. However, government institutions waive that sovereign immunity as soon as they enter into an economic contract, which means an economic benefit to them as well as the other side. And when that happens, sovereign immunity is waived. But what ends up happening is that you got to take a look at the contract. You got to take a look at their budget. Is that money budgeted for your contract or not? And usually it's only done on like a 12-month or a 1-year cycle. And for the upcoming year, if it's no longer in the budget, they will often have the right to actually terminate that contract by statute. If you want it to be longer than a 1-year period, that requires a whole other level of approval, and that can get fairly hairy. Government contracts also know that there's politics in the background. There's governmental appointments in the background. There's people that have been appointed to be the gatekeeper, and they have politics that they have to cater to. So if you see like hospital districts being like Broward Health or Jackson or Memorial, these hospital systems are a semi-political body, and they've got to comport with these rules and regs. And they have to keep in mind the politics that are in play. Ed, anything you want to add to that?
No, I just keep in mind the policy in play. We're dealing with hospital districts because again, the boards of these hospital districts are elected by the local electorate, which means they're responsive to the interest groups or certain groups that might have a key interest in what the hospital district is doing, and that might change the dynamic of negotiations, change the dynamic of the type of arrangements they're entering into or who they're entering into contracts with.
So, all right, so now we're going to talk about unique contracts that are really unique to hospitals, okay? So there is what's called a management agreement. In a management agreement, a hospital will go out and contract with a third party to provide a professional or administrative service to a hospital division. Usually it's to a department, and they come in as either consultants or they come in as a medical group. It's like, for example, you might have your pediatric ward be taken care of by a pediatric group. The pediatric group runs the whole pediatric ward. They appoint their own medical directors and management and oversight to be able to run that pediatric ward. Now, when a hospital system is getting ready to engage in something like that, you got to do your, dot your I's and cross your T's. You got to check for license and insurance. You got to check for DEA registration. You got to check for medical staff privileges, making sure that they're up to par, making sure that the non-compete agreements that you're about to enter into, or provisions that are in the agreement, that the non-competes is something you can live with. And vice versa, right? So it's got to go both ways. And then you also should be looking at pending and threatened litigation of that third party. And when you're about to actually, when you're negotiating these management agreements, do take a look at post-termination clauses, because the right to terminate may have a delayed effect. Like, you may not be able to terminate a contract at a moment's notice, or you may be able to. You just don't, like, you got to take a look at those termination clauses, how it's written. Some contracts will require a 3-month advance notice. Some will require a 1-year advance notice. And some, under certain circumstances, may be terminable upon the occurrence or immediately. But when that happens and you terminate a contract, what do you do next, right? So now you got to bring in a whole other team so the old team can actually depart. Here's where, Ed will walk you through some of his stories. But yeah, Ed, you want to?
Yeah. So a lot of my focus in the last, maybe 12, 15 years has been on the physician side. So on these agreements, you got to keep in mind on termination. Let's say you're a group that is staffing the hospital, and this is what the attorneys are looking at when they're doing the contracts: is you're staffing the hospital and that department, and the ability for the hospital to terminate you. What's the notice provision? Because you obviously have a provision in there. It'll say, if you are terminated, your folks are no longer on the medical staff, or no longer can service at least that department. Now, how long is you be able to find place to put all these physicians? If you have 30 days notice, can you in 30 days find another a provider? Another place to go, or you might have to terminate your physician agreements. Do those termination notices align with your underlying employment contracts? Similarly, what's the transition? What time of day does one leave and the other group come in, so that there's actually a matching up of the care, so there's a continuity of care with the patient. And finally, even though the group is no longer at the hospital, what is the hospital's obligation to provide the information on the information bill on the patients that were billed, so that the group can continue to bill for, or can bill for the services that were provided up to the termination date. Obviously making sure people cooperate. So those are just keeping in mind what happens when everything goes away, and work those out beforehand in the contract, so that there's not a disruption as much in the care to patients, because the underlying everything is making sure the patients are taken care of, but then also making sure there's not a disruption as much in either of the parties' businesses.
Next, we have under arrangement agreements. Under arrangement agreements are also relatively unique to actually hospitals, and they're similar to the last set that we talked about, except they're a little bit different. They're a little bit more periodic, a little bit more temporary, but they still help cover the gap. So, for example, a hospital may bring in a physical therapy group or an occupational therapy group that comes in and provides those therapies to the patient. Or they may bring in a diagnostic inpatient service. So they might bring in a specialized diagnostic service that comes into the hospital and does the work. Now, the unique thing under arrangement agreements is that the hospital does the billing for those services. Those third parties don't. The hospital does. So, and Medicare specifically allows for that kind of billing to take place with under arrangement agreements. And, with that, you got to be cautious of Stark and anti-kickback statutes, the AKS, the anti-kickback statute. And, what'll happen is that the way CMS looks at it is that the contracted party stands in the shoes of the hospital. So they will hold both people are responsible if something goes wrong, the hospital as well as that other third party entity. And it's something allowed under the rules and regs, but be careful of it as to who the responsibilities fall onto. Another unique set of agreements is grants. Grants often have a grant agreement. So like, for example, the Ryan White grants that come out, right? So every year there's a renewal on those. And when you renew those, you know that it's got a specified purpose to it. You know that the use of funds has to go to the community benefit for the HIV issues and, that sort of stuff. And then there's actually representations and warranties that the management is giving and saying, you know what, we got the funds, we use the funds, and we use them in the particular manner that the grant stated that it should be used in. And sometimes there's also a reporting back requirement. So meaning that you've got to go back and now update the grantor as to what the monies were actually used for. So be careful that, again, then you have PHI transferring, going back in time. Now, all of these agreements kind of permeate in the underbelly of the hospital system or the healthcare system. And, there's also a uniqueness as to actually telehealth and the telehealth services contracts. And for that, Komal, would you like to?
Yes, thank you, Ben, for the introduction. So today I'm going to talk to you about the specific clauses that you should really pay attention to when it comes to telehealth services contracts. This discussion builds upon a previous presentation that we brought to you in September regarding the legal pitfalls and pointers for telehealth services. This is a growing field, especially because of the pandemic currently. And the first clause that I would really like to bring your attention to when you're looking at your telehealth service contracts is the clause that addresses the infrastructure and connectivity. You want to make sure that it is very clear as to who will be providing telehealth infrastructure and connectivity, meaning your software and hardware, and who's going to be responsible for making sure that the service provider is going to be trained, appropriately trained, and who will be providing that training. In addition to that, you want to pay attention to your cybersecurity clause. The main issue being here, you want to pay attention to who will be held responsible in the event of a cybersecurity breach. If there is a breach, you want to be able to make sure that either the telehealth provider, as in the service provider, or the person that they're contracting with or the facility that they're contracting with is clear as to what to do moving forward, depending on that responsibility. Additionally, you want to pay attention to whether liability insurance specifically for cybersecurity is going to be provided, what that coverage is going to include, and what the insurance limits are going to be. Many people tend to make an error or a mistake, a human mistake, honestly, in overlooking their exceptions. Sometimes the cybersecurity insurance policy may not include a cybersecurity breach. And so you need to pay attention to those issues.
The exclusion clauses are really important. So.
Right. They are very important. Additionally, another important clause is your warranties. Many of the hardware and software contracts for telehealth services will provide an as-is clause or a use at your own risk clause. These are typically normal. But just so you know what's covered, you should really pay attention to those. And finally, the most important clauses would be those addressing your services, billing, and compensation. You want to make sure that the contract is clear as to which forms of services or what type of services will be provided through the telehealth contract. And you want to make sure that the appropriate credentialing process is adhered to. You want to make sure that you're following federal and state guidelines. And then at the end of it, you want to make sure that your provider of record is clear, meaning who's going to be responsible for billing, who's going to maintain the provider-patient relationship. Is it going to be the service provider, or is it going to be the facility through which they're contracted? And then ultimately that will also help you address the compensation model, meaning how will the service provider be compensated for the services provided to patients. These are all overarching issues within the healthcare contracts realm. These are important issues that you need to pay attention to. And other issues, another issue that is often included in, that should be looked at would be the bond financing for hospitals, which Ed will be discussing next.
Yeah, so again, telehealth, telecommunication, that touches so many pieces of a hospital. And so it's so important to understand, the various rules that deal with telecommunication and that might touch the contracts. Similarly, and this sort of, people wonder, why do I need to know about bond financing? That's because there's a lot of hospitals out there that are tax exempt. And the difference between a tax exempt hospital and a for-profit or investor-owned hospital is the for-profit investor-owned hospital is able to go to Wall Street and issue shares to get additional funds to fund expansion, be it an expansion of a facility, a new wing, or major pieces of equipment that need to be financed through through their shares. A nonprofit, however, doesn't have shares to issue. A nonprofit has to borrow, and they will often go to the bond market, issue bonds, and those bonds most likely will be tax. They're going to seek tax exemption because that means the buyer of the bonds doesn't have to pay income tax, state or federal income tax, on the interest received by the issuer, the hospital issuer, from those bonds. Now, those bonds, to be able to remain tax exempt, have to meet certain requirements. Otherwise, they can lose their exemption from tax exemption, which of the bond. So that could hurt the holder as well as the hospital. Similarly, the bond counsel has to give their blessing on the bond itself, saying this is tax exempt, will want to be looking at all of your contracts to make sure there's nothing in any of the contracts with the hospital that could affect the tax exempt nature of the bonds. And basically, keeping in mind, when something is bond financed, that means the bond financing, that piece of property, that portion of the premises are subject to the bond rules, or that large piece of equipment are subject to the bond rules, which means that only about 10% of the proceeds from those bonds can be used by a private business. Private businesses being physician groups, being other for-profit groups that might be in there. And this can implicate leases. If there's bond financing of a space that is then leased to a private business, or management contracts such as a physician group in a department of a hospital that's taking, let's say, they're now responsible for the ICU unit. They're exclusively right to use that ICU unit. That can implicate and cause problems for the tax exemption if those contracts are not used appropriately, or not structured appropriately to maintain the bond financing. But there are safe harbors. There are safe harbors to these rules, and that's a need to keep in mind when having contracts for use of that might use bond finance facilities. Again, departments or that are built with bonds that are tax exempt, or big pieces of equipment. And what are those rules? And there's a whole slew of them. Now, I remember, and these rules come out at different times. So the most recent one is Revenue Procedure 2017-13. So it came out in 2017 by the IRS. And when this revenue procedure came out, those who hadn't been focusing on it all of a sudden realized, oh, why is my contract now requiring certain provisions? Because the bond financing rules, the bond counsel says these provisions must be in the contract. Things like, obviously, reasonable compensation. The compensation must be reasonable. The share of net profits cannot be shared from the operation of the managed property. And the hospital must exercise, the contract must say the hospital can exercise a significant degree of control, which means it must be in the position to approve the annual budgets for that affect that space, must approve capital expenditures, must approve the disposition of the space. So while the physician organization using that department, that has the exclusive right to use that department to staff it 24/7, 365 days a year, have an interest in the budgets, the capital expenditure. That may be a good source for the hospital to look through the budgets and expenditures for that department. They can't be in a position to actually approve the budget. That they have to run a Bible. They can't be approved. And in addition, and this is what really threw a lot of people off when these bond rules came out, they have to say, the contract must say that the rates charged for use of that department that's financed by tax-exempt bonds, that space that was built with tax-exempt bonds, must be approved by the hospital. The hospital must approve the rates charged, which many groups started balking at, but the IRS clarified that, well, it's enough if you approve the methodology. The hospital approves the methodology to determine the physician group's rates, which then, relieve some of the concerns that the groups had, that hospitals now knowing exactly what they're charging patients. So again, the purpose of that, of course, is to make sure that the group is not taking advantage of the use of that facility to overcharge patients. And very important, I guess, for those who are accountants on here, the contract itself must say that the service provider, the group that's in there, or if it's leasing the space, is not entitled to, will not take any tax position that is inconsistent with being a service provider to the qualified user, meaning the tax-exempt hospital, with respect to that managed property that is funded by tax exemption. Now, what does that basically mean? It means that the service provider in that facility space must agree that it will not take depreciation or amortization, investment tax credit, or a deduction for any of the payments as rent with respect to the property in which they're managing. So that's a key provision that has to be in these contracts that are management of wings or departments of the hospital. So I want to then skip now over to the issue of the Stark regulations. New Stark rules came out recently, and they're going to be effective January 19th of 2021. And they did several things, and we're going to talk at a later next month more specifically on what these regulations are, what these key changes are. But keep in mind that they address some common elements that are found in many of the exceptions, such as fair market value, commercial reasonableness. Especially in the area of fair market value, they clarified that for lease rentals, of space rentals and equipment rentals, that you cannot take into account the intended use of the property on the fair market value for. So, for example, you can't take into account the value attributed to the proximity or convenience of the lessor, where the lessor is a referral source for that space. In addition, they again clarified that for purposes of fair market value, it's the value at the time the arrangement was entered into. The fair market value may change over time, but for the purpose of determining fair market value, it's the value at the time the arrangement was entered into. But they also added a definition that's real important for commercial reasonableness, because many of these Stark exceptions require that arrangements to be commercially reasonable. And they said basically that commercial reasonableness, when it's used for purposes of Stark, is that the particular arrangement furthers a legitimate business purpose of the parties to the arrangement and is sensible, considering the characteristics of the parties, including size, scope, and specialty. But a key line in there was that an arrangement may be commercially reasonable even if it does not result in a profit for one or more of the parties. So the profit factor is not necessarily indicative of commercial reasonableness. So that was a key piece of that. In addition, the next slide, please. The Stark has quite several provisions dealing with facilitating value-based healthcare delivery and payment arrangements. And these basically implicate the Stark law because these value-based arrangements, that is where the physicians and hospitals and various players all get together and go to a payer and say, hey, we'll take care of a target population and provide higher quality of care and meet certain thresholds. But we want to be able to, within our arrangement, because we're taking, for example, full financial risk, be able to require referrals by the physicians within the arrangement for the services under the arrangement to the of the target population. So there's issue. We're going to talk in the seminar about these, but I want to make sure you know that these are something very, very new out there. Full financial risk arrangements where the physicians are taking meaningful downside risk, such as a 10%. They get at least a 10% withhold. That's then only paid if they meet quality or productivity thresholds. And then there's a general value-based arrangement for coordinating care. And finally, there in these new regulations, there are safe harbors that were issued by the Inspector General as a separate set of regulations, again, for value-based arrangements, for donations of cybersecurity and technology. They modified the local transportation safe harbor that's already out there for rural areas, especially, to go up to 75 miles rather than the prior, I think it was 50 miles. And they made modifications to the safe harbors that currently exist for personal service and management contracts. And finally, there was a new rule dealing with telehealth and home dialysis that provides some protection from the civil monetary penalties rules. Again, you think about it, what are we talking at the very beginning? Why does your contract take so long? And then we're thinking all these slew of regulations and arrangements and making sure everything is pulled together and nicely is one of the reasons why your contract takes a while to review. Ben, you want to say anything about that?
Yeah, the provisions that we talked about, like the things regarding non-discrimination, access to books and records, release, indemnity, and waiver, those sorts of clauses are often hangups on both sides. And each side is actually afraid of getting undue advantage taken of them. So they try to hedge against it. What we found best is to actually work with our clients when they, in identifying the business risk and what's the actual likelihood of something occurring. And if it does, how much can it cost the business? And if it's something large and critical, and if it's something that happens frequently or infrequently, those are all really important gauges. So the way we've typically worked with our clients is we've helped them modify their clauses so it matches the risk that they're about to enter into. And then sometimes our clients have issues with just compliance stuff. And they'll call us up and say, hey, I've got this, my contract has been stuck in compliance. What's the best way to deal with it? And we'll work with them and trying to figure out what is the best way to like deal with that compliance issue. Sometimes it's in the actual process. Sometimes it's in the provisions that are included in the contract. So that's kind of where I think, bring value. If you have something, we'd be happy to take a look at it. But anyway, that's contracting in healthcare. That's the industry, and that's where we are.
Great, Ben and the group, I appreciate it. Are there any questions out there for Ben? There's got to be at least one or two. Lots of good information. Any questions from either side? Either you're trying to contract with somebody or you're actually the one getting contracts in from different vendors. Any questions for Ben? Hearing none, everybody understands completely what you've said, you and Ed and Kamal said, which is kind of an amazing situation, but we'll go with that. It's
transmission through osmosis rates.
It is, it's amazing, and people are dropping off like crazy right now. But before you drop off and have a good rest of the day, remember, we will be having 2 more educational sessions with Ben and the group on January 5th and January 19th. We're getting those set up, and we'll send you links to those hopefully this afternoon or in the morning. This video will be available for you to view, and we'll send you the link to that. And also, I'll send you a link to the event, the session we're having on Thursday, which is analytics, AI analytics for your healthcare practice, whether you're a CEO, whether you're in the marketing department, whether you're a physician and wanting to get information about the healthcare system in Florida. Tune in. It's 1 hour. We'll take only 1 hour and show you the different desktop graphs and information we have providing to you, and see if that'll help your practice help you help you have a little bit more education on what's going on in the healthcare system in South Florida. So with that, any last words, Ben, Ed, Como?
When's the
I'm
cold front?
glad. Hope people enjoyed this presentation and found it useful, and we're gonna good, very good.
And like I said, the going and doing a deeper dive into safe harbor and those type of topics will be coming up in January. We've got 2 sessions in January on the 5th and on the 19th. So we look forward to seeing you then, if not before, at either our networking or educational sessions provided by South Florida Hospital News or Healthcare Law Partners. Thank you again, and we'll see you next time. Thank you. Bye-bye.
Thank you.
Guys.
Bye.
Bye.